Consensus of the Appellate Division Fourth Department. Hear ye, hear ye, hear ye. All persons having business before this court will go on there and do their thing, and they shall be heard.
Thank you. Please be seated. The first case on for argument today is case 220, People versus Hartsfield. Proceed, counsel.
Good morning, Your Honors. May it please the Court, Catherine Friedman representing Appellant Curtis Hartsfield. Your Honors, I'm more than happy to answer any questions that you have regarding any of the issues that I raised in my brief, but I'd just like to take a couple of minutes to focus on the two issues that I think are our strongest. First, with regard to the Molyneux issue, it's our contention that the trial court abused its discretion in allowing the complainant to testify as to my client's prior criminal history, and the fact specifically that he had spent some time in prison. It's our contention that not only did this testimony go to the propensity of my client to commit the crime, but also that the probative value did not outweigh the prejudice to my client, because the jury certainly got the impression that my client was a career criminal. And it's our contention that the error was not harmless because we don't believe that the evidence was overwhelming, which gets to my next issue regarding the sufficiency of the evidence. I'd just like Your Honors to...
It's not like her testimony was unclear or it was a stranger that she was identifying.
That's
You're
correct.
saying the proof wasn't strong because there was no DNA?
That is part of our argument, Your Honor.
But there was medical evidence showing that she had engaged in some level of sexual activity that resulted in bruising and bleeding.
There was some evidence. We, however, contend that there was also evidence that demonstrated, for example, when she went to the hospital, her temperature was normal. She did not, there was evidence in the record.
Well, that was hours later.
I'm sorry. It's our contention that the evidence was not legally sufficient. With that, if you have any other questions? Thank you.
Good morning, everyone. May it please the court. Briefly, with regard to the Molyneux issue, I would just note that should the court be concerned about this ruling, I would submit that it would be an isolated error. It was limited damage, which would be limited by the limiting instruction provided by the court, and also the evidence went in much more constrained than what the ruling allowed. I believe the ruling allowed for far more testimony regarding her knowledge of his history, and all that was actually admitted was he had been incarcerated. So we would submit that it would be harmless error should the court be concerned. Thank you.
Thank you, counsel. Case 221, excuse me, that's submitted. Case 222, People versus Zettel.
Good morning. May it please the court. Scott Porter. I'm here on behalf of Appellant Mr. Zettel. And the issue presented in this case is whether it was appropriate for the suppression court to exclude my client from being personally present for his suppression hearing after his attorney asked for Mr. Zettel to be present. And if he couldn't because of COVID concerns, he asked the court to adjourn it for a later date. And this suppression hearing was scheduled for September 11th, 9/11/2020. And as I explained in my brief, at that time, there was in effect an administrative order that said in sum and substance that incarcerated defendants are to be excluded at evidentiary hearings.
Was the argument with respect to the administrative order, was that preserved?
Excuse me, Judge?
Was the, my apologies, as you know, I got to speak up. Was the argument you're making now with respect to the administrative order, was that preserved?
I believe
below?
it.
Was that specifically argued below?
I submit, Judge, and two parts to my answer. The first is that the fact that defense counsel wrote to the court and asked specifically that his client be present at the suppression hearing preserve the issue.
Did he make does the letter make reference to the specifics with respect to the administrative order? That's my question.
No,
Okay.
no, in fact.
Then I interrupted you. You have a second part.
The second part is that if this is not motive proceeding, I don't know what is, because it creates a totally new procedure. And
So you're saying motive proceeding doesn't need to be preserved?
I am, and to follow up on your point about defense counsel not saying anything regarding Mr. Zadel's right to be present, the court never said anything factually or legally as to why it was excluding the defendant from the suppression hearing. And to some extent, I'm making assumptions here, and a safe
Well,
assumption.
excluding from the hearing, he was present virtually, right?
He was.
So he wasn't excluded, he just wasn't physically present.
That's true, but
I just worry about exclusion, makes it sound like he was unaware of the proceeding or didn't get to see it or confer with his attorney.
yes, and one can also say that this was not a virtual hearing. This was an in-person proceeding with one party, one person not participating or excluded, whatever word fits this circumstance, and that's the defendant, the person with the greatest stake in the outcome of this hearing. The cases that the people cite in their brief are virtual hearing cases in which the court, civil, criminal, different stage of the proceeding, holds that it is appropriate because of the COVID pandemic to conduct a virtual hearing for purposes of that case. Here we have a suppression hearing, and we have an administrative order that in effect says that incarcerated defendants, not defendants at liberty, are excluded from being personally present in the courtroom for the hearing. And
Anything further, counsel?
no, unless there's no further questions, I'll
Very good,
sit
thank
down.
you, counsel.
Good morning, may it please the court. Ty Casella for the people. I respectfully disagree with counsel. I do believe that this issue was not preserved for appeal for a number of reasons. The first of which, in that the hearing itself never actually occurred. There was no motion made by counsel requesting that his client be able to be present personally in court. And he waived his right to appeal when he entered a plea, thereby waiving his right to a hearing, to have the court issue a decision on suppression of evidence or suppression of statements or whether or not any police conduct was properly done. He waived all those rights when he pled guilty. And additionally, like the court, I take issue with the word excluded. He wasn't excluded from this proceeding, and I also take issue with the statement that he couldn't participate. He was able to participate in that he was permitted to be present virtually. He would have been allowed to communicate through the court. There's a two-way system. He can talk, he can hear, he can see, we can see. He is as much present in that as if he were physically present. So he was able to participate had it occurred. He was not excluded in any way. So I don't believe, A, that it's preserved, and B, even if it were preserved and the court were to reach it, I don't believe there was an error in this type of proceeding, and that there's support for it in the Constitution as well as the judiciary law to allow such thing to occur under the circumstances that were facing this country and this community at the time that the decision was made by the administrative judge of the 7th Judicial District.
Thank you, counsel.
Thank you.
Case 226, People versus J. Betsy Jones. Counsel, before we begin argument, I'm going to just make a statement, and I should have done this at the beginning. I want to make sure everybody's aware that we still require masks to be worn all throughout the proceedings, both in your chairs back before you argue and when you come forward. If I find that people are not keeping their masks fully in place, covering their nose and their mouth, that you'll be asked to leave and you will not be allowed to argue. Counsel, proceed.
Good morning, Your Honors. May it please the Court. Phil Rothschild from Hiscock Legal Aid on behalf of Mr. Jai Betsy Jones. And the people in this case did not meet their burden of showing the basis for the stop and frisk. Officer Brown was told by his partner, Officer Dorchester.
Mr. Rothschild, the stop is fine, right?
It's debatable, Your Honor, insofar as the people never produced the actual printout from NISPIN showing their basis for it, so we have a hearsay upon hearsay issue. But I would submit that that also extends to that was never introduced at the hearing, Your Honor. There's no indication, it's not shown as an exhibit. So that's debatable, but I think that also extends to whether or not they had probable cause to seize him and take him from the car. So that's...
That would only be based on the lack of a license, right?
Well, as far as the license, the other point I'd like to address is that what Mr. Jai Betsy Jones said was, I have a license, it's just not on me, you guys can check it. And clearly, they had the ability to check it because they had a computer right in their car. There's no indication that they did. And I would note for the record
And
that...
not having a license, I'm sorry to interrupt you again, but in not having a license, does that in itself allow the officer to remove the defendant from the vehicle and search him?
I would submit that it does not in this case. Back in the days when I
Why
started...
not in this case, and would it be generally allowable otherwise?
I would submit, Your Honor, the difference is back when I started, they didn't have computers, they didn't have the ability to check this stuff. Here they clearly did because that's their testimony. They have this computer.
So your answer is no, they
No.
didn't have a right to grab him out of the car at that point.
I think what they should have done, just as they should have done the printout, they should have basically checked with it. And I would note for the record, there was no such ticket issued. No ticket issued either for the switch plate and no ticket for the license.
Well, back in the old days, when we didn't have computers, would this be allowable in terms of taking the defendant out of the car and searching him based on the absence of a license? Is that the law?
I think you'd have a much stronger case in there, Your Honor, insofar as basically the officers had the ability to do this. The officers could have simply checked this. He told them, I have this license, just check it up. Clearly, they were able to do that. They didn't. They
But
didn't
it's
issue a
presumptive
ticket.
evidence that you don't have a license when you don't have it on you in the vehicle, right?
Yes, but that presumption is rebuttable. It's not an irrebuttable presumption. And I would submit in this case, especially given that they said, hey, we have all this computer stuff, they could have done it. They didn't. They didn't meet their burden.
The question I have, and Justice Curran has hit upon it, is do they have an obligation? In other words, maybe best practices should be changed, and maybe they should be required to do the search. But do they have a legal do the officers have a legal obligation to do that search? Or if, when presented with a driver without a physical license, that's enough?
I would submit in this case, given that, first of all, they had their doubts about whether or not this was, as far as the switch plate, whether in fact that was illegal. That was the testimony of Officer Brown. He wasn't sure. And as far as the license, I think that there is, obviously the police officers have discretion, but there should be, they should exercise that based upon the information they have. And I would submit in this case, there really wasn't proof. I was all set to argue about how the marijuana law should be retroactively applied. And I looked at the decision again and I saw that the judge in fact did not credit that. So I don't, based upon that, we would submit that the people did not meet their burden of proof in establishing any of the traffic infractions in order to justify taking him out of the car. And this court should reverse and dismiss the convictions.
Thank you, counsel.
Good morning, Your Honors, and may it please the Court. Jessica Carbone for the people. First, with respect to Justice Curran's question about the legality of the stop itself, I just wanted to note the testimony that the plates were on the wrong vehicle, that the Jeep plates were on the Subaru, was uncontested at the hearing. And in fact, the defendant's
Well, the
own
plates actually were on the right vehicle, ultimately we find out, right? Because there was a transfer, and transfers happen all the time, and then there was a temporary registration. So the plates weren't on the wrong vehicle. The plates were on the right vehicle. Wouldn't you agree with that?
Well, I think at the time of the stop, they were on the wrong vehicle because the registration had not been finalized.
At the time of the stop, wouldn't you agree they were on the right vehicle, but the officer may have had a proper reason to inquire as to whether they were on the wrong vehicle? But is there any evidence in this record to indicate that the plates were actually, once he inquired, were on the right vehicle?
I mean, I guess it's a question of whether the DMV temporary registration is as good as a final registration.
Is your argument that the suggestion is that people who are driving around with a temporary registration are violating the law?
No, I think the difference here is that they took the plates off a different vehicle. So if you were just driving around with a temporary registration and it didn't come from a prior vehicle, there would be nothing to run to see that it was on a different vehicle. This particular license plate was registered at the moment, at least, to a Jeep, but it was being used on a Subaru. So I don't know the answer if the DMV's temporary registration is as good as a permanent registration. I don't know the answer to that. I apologize, Your Honor. But I do believe.
Ms. Carbone, I'm more interested in terms of, in addition to that, with respect to the frisk of the defendant so immediately, I don't see any testimony from the officer that the absence of a license is the reason why he had the defendant or tried to get the defendant out of the vehicle. And it had to do with the marijuana. The marijuana's really not in this case at this point. So tell me about that frisk of the defendant. Why was that lawful, if at all? And do we have the testimony to support it at the hearing? That's my key question, I think.
I think it was a totality of the circumstances. You had, well, from the officer's point of view, you had what appeared to be an unlicensed driver operating a vehicle that did not appear to have proper license plates. The officers detected the odor of marijuana, which
Forget the marijuana, because the judge below didn't give any credit to that, okay?
Absolutely, Your Honor. But I will note that that testimony was in the record, and the judge did include that as part of his decision. The competing testimony from Ms. Stevens, the defense witness, that the car did not bear the odor of marijuana is sort of what led him to, I guess, eliminate that as a basis. But in addition to that, he had been asked to step out of the vehicle. He was not exiting the vehicle.
Does it matter why he was asked to step out of the vehicle in terms of the testimony of the officer? The officer didn't testify. I asked him to leave the vehicle because I didn't think he was licensed. It had to do with the marijuana. The marijuana's out. So do we have enough testimony from the officer vis-a-vis the unlawful act, that is not having a license or alleged unlawful act?
And not only that, it appears that the officer wasn't even sure if it was okay or not that he didn't have it. So that makes it even less stringent that he might have some right to get him out of the car.
I certainly concede that the officer did not testify that it was his intention to arrest the defendant for operating without a license. We don't contest that point at all. But I think that in judging the, I guess, lawfulness of the officer's act, we have to look at what he believed at the time. So yes, we all know that the judge later found that the marijuana was contested at the hearing, and that was not the basis. But at the time,
it wasn't just contested. He didn't believe the officer. Okay.
I actually disagree respectfully, Your Honor. I think the decision makes it clear that because Ms. Stevens came and testified that she didn't smell marijuana, that we didn't meet our burden in proving that. The judge never said he did not credit the officer's testimony, simply that the fact that it was contested by another witness could not form the basis for it. But, Your Honors, I think that the judge's decision here reflects a very thorough balancing and weighing of the evidence. He did partially grant suppression, and I don't think that there's anything in the record which would render the rest of his decisions erroneous. If there are no other questions, I would rest on my brief.
Thank you, Counsel.
Thank you.
Case 228, Cyrus versus Rochester Regional Health. Proceed, Counsel.
Good morning, Your Honors. May it please the Court. Claire Bopp on behalf of the defendants, appellants, Rochester Regional Health and Unity Hospital at Park Ridge. Your Honors, this is a complicated, serious medical malpractice action involving numerous significant questions of fact.
What are the...
Yeah, I'm sorry, yes, Your Honor?
No, go on.
Oh, sure. And the Supreme Court's own decision, the written decision below, makes clear that questions of facts do exist here when it found, quote, Dr. Van Rooyen's affirmation does point to certain actions of defendants which tend to counter plaintiff's assertions. That sentence alone, which is found on page 2 of the written decision, should have precluded summary judgment right then and there. And for that reason, among many others, we respectfully request reversal by this court. Plaintiff, as the movement here, bore the heavy burden of establishing the absence of all material issues of fact. She completely failed to...
All material or every material. If there's facts raised about whether Weaver Dr. Weaver practiced appropriately or met the standard. But your expert raises nothing about the phlebotomist drawing the blood correctly, the people being on overcall overnight, the physician assistant, hospitalist not doing things, and none of that is raised. You're saying the fact that you raised one issue about Dr. Weaver is enough to deny summary judgment against the hospital?
Well, Your Honor, respectfully, plaintiff here as the movement bore the burden of proof with her own evidentiary submissions, including her expert's affirmation, Dr. Painter, as well as all of the testimony that she included.
But if we presume they met their burden, and you raise an issue about Weaver, is that enough to deny summary judgment against the hospital?
Well, Your Honor, respectfully, yeah, I would answer yes, and we believe that in addition to Dr. Weaver's testimony, which creates genuine issues of material fact by plaintiff's own submission, thereby she didn't meet her burden, that defendants certainly met their burden in opposition through the submission of their own expert affirmation, Dr. Van Rooyen. And as it relates to Dr. Painter's affirmation, Your Honors, it is our contention that those opinions should never have been considered by the court below because he failed to review the complete evidentiary record in this case.
But didn't Dr. Painter certainly had all the medical records there and reviewed all those and had gone through those? That would be enough.
Well, Your Honor, respectfully, I would disagree with you that that's sufficient because as this court held in Dualewski versus Tolini Richard, an expert who fails to review the complete evidentiary record in a medical malpractice action, those opinions are of no probative force, and that includes deposition testimony. And I think that that's critically important in a case like this because the allegations of malpractice here stem from, oh, yes, Your Honor.
Let's go back to that case. In that one, it didn't even address whether the plaintiff's expert had reviewed or relied on any certified medical records. In this case, it's very clear that Dr. Painter relied on those medical records.
Yes, Your Honor.
I think that's a very important distinction.
Your Honor, certainly, and I appreciate that. I think the difference here, though, is that the allegations of malpractice stem from what the medical community jargon is the differential diagnosis process, which in lay terms means what is the attending physician, what is his decision-making process when he's evaluating a patient, when he's undertaking a plan of care for that patient, and certainly not everything that is done in a hospital setting is transcribed and documented in a hospital record. So it is critically important in this type of a case where the allegations stem from Dr. Weaver's purported violations of the standard of care in his decision-making process to actually review his testimony and see, what was he thinking when he was evaluating and treating Mr. Cyrus in the emergency department that afternoon. One of the things that plaintiff takes issue with in her respondent's brief, for example, is that, and to the court below, is that aortic dissection was never, the words aortic dissection is ruled out do not appear in the hospital chart, which is true. That being said, though, Your Honors, Dr. Weaver clearly testified that he had clinically ruled out that diagnosis on clinical grounds based on Mr. Cyrus's history, presentation, his description of the onset of his pain and how he characterized it, that it was very atypical and unusual for a patient to be experiencing aortic dissection, but having symptoms that manifest in that manner. So the fact that it's not...
I don't believe he said it was atypical.
I think Dr. Weaver's testimony was very unusual, very unusual. And so that wouldn't be something that you would expect to find. Dr. Weaver testified that he, based on his clinical presentation, he described what he believed the likelihood of that diagnosis of aortic dissection to be, quote unquote, vanishingly small. And because of that, he was able to rule it out on clinical grounds without seeking further contrasted imaging studies.
Knowing that something of this type, if you catch it early, which could have been done with that CT contrast, you could probably save somebody. And knowing that, didn't bother to do it.
Your Honor, respectfully, I think that, this is kind of putting the cart before the horse. So a bad outcome, in this case, of course, Mr. Cyrus passed away, and that's very unfortunate. But a bad outcome doesn't mean that a doctor
understand.
violates the standard of care. And certainly, Dr. Weaver's testimony is
So
that it's
you're-
not.
I mean, you're simply saying, let the jury decide this. Let the jury hear the testimony from the doctor about what his processes were, why he was making these decisions, and let's let them decide based upon the facts presented at trial.
Absolutely, Your Honor. I think that this is a case, if any case should go to trial, it's this one, because there are credibility determinations that need to be made. Certainly, Dr. Weaver's testimony is very important. It is a critical piece of evidence here in terms of what was his decision-making process, why did he do what he did?
But
why-
again, you're focusing just on Weaver. What about physician assistant Vic, the admitting provider, who saw the person over the night, was concerned about the blood not being drawn, never talked to the attending hospitalist about the test? He was concerned. He said he actually used the word scared, considered CT would contrast, but scared of kidney failure, but didn't talk about it with the attending hospitalist who never called in overnight. What about all of that? I mean, Weaver's one, but Weaver isn't the named defendant.
Right, you're, well, correct, Your Honor. No, there are no individually named defendants here. And I would just go back to the fact that, of course, Dr. Painter didn't review anybody's testimony whatsoever, including PA Vic's. And I think that that also undermines the plaintiff's position on the issue of causation, because, of course, Dr. Painter puts in his affidavit that Mr. Cyrus was hemodynamically stable such that he could have been transferred out to a different hospital in order to undergo the surgery, because that's a second element of their cause of action, right? Unity Hospital is not the type of facility that's going to perform that kind of
But it
surgery.
can.
It can, but in all likelihood, this gentleman would have been transferred to Strong or possibly Rochester General. And in order for him to make it to a different hospital, make it through the operation itself, that's also a question for the jury. And I think that undermines.
But nobody's contesting physician assistant Vic's testimony that the blood draw was to be done at 4 a.m. It's not done. He calls at 4:55, says you got to do it. He then says he calls multiple times and frustrated by the failure. He said the blood was not drawn until 7:50 after his shift was over. He said it was a recurring problem with that unit, and the blood work did in fact show damage. And Vic said if he had seen that there was heart damage, he would have had an opportunity to diagnose an aortic dissection before it was too late to help this person. Yet your doctor expert never addresses any of that.
Your Honor, that's true. And I think, though, that this all goes back to, the issue of whether or not something could have been done. Basically, if something could have been done differently doesn't necessarily mean that Mr. Cyrus's outcome would have changed. So, there is case law to support that, just because, a nurse doesn't take vital signs at the appropriate time when it's ordered at 7 p.m. Well, if that failure to do so doesn't actually change the patient's ultimate outcome, then in terms of a medical malpractice action, it doesn't matter. And certainly
But here
the
we
issue.
have physician assistant Vic saying it would have made a difference.
Well, Your Honor, I would just go back to the fact that causation in this type of a case would be a question for the jury. Certainly PA Vic as a mid-level is not an expert. He's not a doctor. He's not even, I would submit.
But he was the only one who treated him overnight. The physician, the hospitalist never called in, never reviewed, and didn't even discuss it with PA Vic that night, did he?
No, that is true, Your Honor.
And isn't that another claim of malpractice against the hospital?
It is, Your Honor, yes.
And is it addressed by your expert?
It's not addressed by our expert in the affirmation. No, it's not, Your Honor. But, in terms of the totality here, I think going back to what Justice Whalen mentioned earlier, there are certainly triable issues of fact here. The plaintiff's evidentiary submissions, a totality review of them indicates that, she has raised questions of fact. She has not eliminated them. And for those reasons, Your Honors, we would respectfully request reversal by this court.
Thank you, counsel.
Thank you.
Peter Rogers, Your Honor, for the plaintiff and the respondent in this case. May it please the court. This court should affirm the decision of Justice Taddeo below. On this record, Justice Taddeo was correct. It is undisputed. There are no questions of fact as to the following critical factors that mandate summary judgment. Mr. Cyrus presented to the emergency room at Unity Hospital 22 hours before his death. Within 2 hours, aortic dissection was included in the list of the differential diagnosis. Those possible disease entities which may explain this man's symptoms, and this one can cause death, as they all knew. It's a life-threatening condition requiring immediate medical intervention. The rule of medicine requires that a life-threatening condition be eliminated, be ruled out, be either confirmed or ruled out, and if it's confirmed, it needs to be treated immediately. And that rule of medicine is incorporated into the regulations, the health department regulations in New York State. It's a critical value test.
Is it important for the jury, though, to hear from Dr. Weaver with respect to what he was thinking in terms of this differential diagnosis, which I think was far down on the list of different, maybe at the bottom of his differential diagnosis? Does the jury need to hear from Dr. Weaver as to why he didn't order the gold standard CT angiogram?
Not in this case, and let me say why. As Judge Nemoyer points out, this is a 22-hour hospitalization. Dr. Weaver saw Mr. Cyrus about 4 hours into that hospitalization. So 18 of the 22 hours of this hospitalization, during which time there were a multitude of departures from the standard of care articulated by Dr. Painter, are completely ignored by Dr. Van Ruyten in his response. There is no question of fact. Not only did they not squarely oppose those departures, as is required by this court, they didn't address them in the least bit. So on that ground alone, we're entitled to a summary judgment. But let's get back to Painter, or to Weaver. At 4:45, he sees Mr. Cyrus for 15 minutes. He writes in the record, the differential diagnosis is aortic dissection. He said, I didn't think it was likely. Okay, that doesn't mean you've ruled it out.
Well, especially if it's something that needs to be addressed immediately.
Precisely. He never wrote in the record, it's ruled out. There's a CT scan, the abdominal CT, which was abnormal, which was consistent with an aortic dissection, because it listed atherosclerosis and calcification as seen in the abdominal aorta. That's an abnormal finding, as is confirmed by the chief of radiology at Unity Hospital immediately after Mr. Cyrus's death, when Dr. Lavazetta went to see him and said, I don't understand what's going on here. Let's take another look at this CT scan. And Dr. Thrall, the chief of radiology, said, yeah, there's atherosclerosis and calcification. Dr. Weaver never looked at that CT scan. He's required to look at it under New York State regulations. It's a critical value test. And it did not image the thoracic aorta, which is where this dissection began. So let's go further with Dr. Weaver, because you're interested in this, Judge Whalen. Dr. Weaver testified that the way you clinically rule something out includes the history, the examination, imaging, and testing. That's in his deposition. He didn't look at the images, so we can't clinically rule it out. And
so you're
finally,
saying he relied too heavily on the history, which in this case, there was a bending over and then apparently a sudden onset of pain in locales that would indicate to him that the diagnosis was something other than, at least primary diagnosis, something other than the dissection issue that we ultimately had, the aortic dissection.
he ignored the test, which was abnormal and suggestive of aortic dissection. He ignored the fact that aortic dissection can be an atypical presentation.
Well, not
It
only
doesn't-
that, though, some of the symptoms that he presented with to begin with are consistent with the.
Exactly.
aortic
His
dissection. Anyway, it's
his
not
symptoms in
something
the
that-
beginning were consistent with. It was, they were correct in putting it on the differential diagnosis. But Weaver was incorrect in taking it off or in saying it's clinically, and not doing anything about it. He never told anybody in the hospital, I clinically ruled out aortic dissection. He didn't tell that to P.A. Vick or Labazetta or anybody else. He left. And then the other attending left as well. And this man is sitting in the hospital for 18 hours. A doctor never sees him, and he's dying right in front of their eyes. And his condition is changing. New symptoms, all consistent with aortic dissection. There's no treatment. His blood pressure is not managed. In a patient with an aortic dissection, you have to manage the blood pressure, or you're simply exacerbating a life-threatening
Counsel,
condition.
let me ask you another question. Justice Niemoyer has raised the issue with respect to the failure of their expert to address anybody other than Dr. Weaver.
Correct. It's a fatal flaw in this case. On this record, they can't win because Dr. Van Ruyten ignored 18 of a 22-hour presentation, hospitalization, leading up to his death. And what happened during that period of time, which Dr. Painter addresses in great detail, and Dr. Van Ruyten doesn't touch. He doesn't talk about it. Therefore, it's all deemed admitted. It has to be. But what happened? His condition deteriorates. He has new symptoms, palpitations, emesis, gait problems. His blood pressure is not checked. His vital signs were not checked. They were required to be checked every 4 hours. It wasn't done. Vic, in the middle of the night, says, I need to do more testing on this man. But before I can do more imaging, a CT angiogram, that's the gold standard, I need to get the blood work. He orders the blood work.
Right, and we know that he doesn't.
They never came to look at it. He wasn't seen by a doctor, Mr. Cyrus, for 18 of the 22 hours until just minutes before he died. So on this record, it's clear. May I say one last thing on proximate cause?
Go ahead.
Dr. Painter addressed the issue of proximate cause. Oxygen depletion, Your Honor, with these masks.
I understand.
Just 1 second.
We'll
On
be
this record,
We'll be patient, of course. Go ahead.
on this record, there is no issue of fact on proximate cause. Why? Dr. Painter said this man was hemodynamically stable. His blood pressure did not precipitously fall until 7:30 in the morning, 2.5 hours before he died. Said there was plenty of time to treat him, to get him to an operating room, to have him evaluated by a vascular surgeon, to operate if possible, to control his blood pressure, which would stop the movement of this dissection, and none of that was done. On this record, Dr. Labuzetta testified they do perform this surgery at Unity Hospital. And finally, if we look at the autopsy results, when that CT scan was done, it's true, there was no visible evidence of an aneurysm at that time. What does that mean? He could have lived if they had gotten him into an operating room. On this record, they don't dispute it, therefore we're entitled to summary judgment.
Counsel, thank you. Case 229, Norris versus Williams. Counsel, may I ask who you are and what your...
I'm with the respondent, Gordon Williams.
Okay, you're not preparing to argue today, is that right?
We have put in papers.
I'm simply asking, are you going to argue today?
Depending on how plaintiffs will likely...
No, there's no depending on. Do you want to argue today?
Yes.
Okay, then you need to sit up here. Sorry for the confusion. Counsel, proceed.
Good morning, may it please the court. Your Honor, is Richard Nicotra for plaintiff appellant Mario Norris, sorry. Your Honors, Mr. Norris, apparently before the bus came, like a lot of people do, was off the curb in the street waiting for the bus, thinking maybe it would come quicker, I guess. The defendant admits having words with Mr. Norris. The characterization of that conversation is a bit different depending on who you ask. Either way, the bus driver was unhappy with Mr. Norris standing in the street. Mr. Norris says that he was giving it to him, he was unhappy with him.
Counsel, just let me understand this argument. There is an accident at this intersection.
Correct.
A car is going down the wrong way.
Yes.
Right? And the bus driver testifies, he looks both ways. When the collision occurs, it happens instantaneous. Your argument, if I understand it correctly, is that the bus driver somehow operated this vehicle because he had words with the passenger who he then noticed in the mirror was standing, retrieving something, and that he intentionally operated the vehicle to hurt the plaintiff. Is that your argument?
Your Honor, Mr. Norris is a colorful character. The argument is that this bus driver specifically was looking at Mr. Norris when he should have been looking at the street. My client specifically states that not only at the intersection, but the whole ride, he was looking up, looking down, looking up, kind of making faces at him. My client says...
But your client doesn't know if he was looking in the mirror at that time because his back was to the bus driver in the mirror, so...
And Your Honor, I think in the record at page 427 and page 73 and 74, Mr. Norris also states that he was looking right at him in that rearview mirror, and then next thing you know, he's flying. So there is specific testimony by Mr. Norris that the bus driver is looking at him in that mirror.
That was disputed, as I understand it, at oral argument. But looking at the law, it's clear that the bus driver had the right of way. The bus driver testified he looked both ways. He had taken his foot off the accelerator. It had hovered over the brake. He was under the allowable speed limit. I thought the case law, particularly from the Fourth Department as recently as 2016 in a case called Penda versus Duval, says although a driver with the right of way, which is what you're arguing, has a duty to use reasonable care to avoid a collision, a driver with the right of way who has only seconds to react to a vehicle that failed to yield is not comparatively negligent for failing to avoid the collision. This case seems even stronger because the vehicle that Mr. Williams was driving came the wrong way out of a one-way street, and Mr. Williams himself said he didn't see the bus until the point of impact. So how you're saying the bus driver should have seen what was there to be seen? Apparently there wasn't anything to be seen before the collision. And the case law seems to say this is, you're arguing about the applicability of the emergency doctrine, that he should have done something else after, or he should have seen the car sooner.
Your Honor, Mr. Norris's position is this, because the bus driver admits he did not see the car until it was inches from his bumper. These are city streets in the city of Buffalo that are multiple lanes for each street, big runways. And what happened here is the bus driver, instead of looking forward, was looking at Mr. Norris. So the case
Well, that's
law...
not the bus driver's testimony, and it's not, as I read the record, it's not your client's testimony at the time of collision. He didn't see the collision. He didn't see what the driver was doing at the time of collision.
Your Honor, at page 73 and 74, Mr. Norris does say that the bus driver was staring at him in the mirror, and then the next thing you know, he was flying. So if the bus driver had been looking forward, Judge, at nighttime with the headlights on of this other car, it's inexplicable how it wasn't, not even a flash was seen. Nothing was seen until this car was inches from the bus's bumper, and that is because the bus driver was looking at Mr. Norris in the rearview mirror instead of looking where he should have been looking.
Well, Mr. Williams also agrees he didn't see the bus or the headlights from the bus until, because of the way the intersection was, and that it's undisputed he came out of the wrong way street.
Correct.
Okay.
I think we have your argument. Thank you, counsel.
Good morning, Your Honor. May it please the court? Vicki Burnett on behalf of defendants
Counsel,
NFTA.
I know this issue was raised before at an oral argument. Does the plaintiff say at the time of the collision, the driver was looking at him in the mirror?
He does not say that, Your Honor. On page 444 of the record, Mr. Norris testified that he turned around to pick up some bags that were on the seat behind him. In that 3 to 5 second time period, it took him to stand up, turn around, and retrieve his bags. He was then thrust forward at the time of the collision. So he was not looking at him at the time of the incident in question. So he can't speak to what the bus operator saw or was doing in those 3 to 5 seconds before the accident occurred. And beyond that, Your Honors, we feel that our co-defendant Williams didn't obviously submit any papers in response to our cross motion and therefore really has no standing to argue in this case. But I'll take any other questions if there's anything else.
No questions. Counsel, thank you.
Thank you.
Your Honors, Laura Gardner for respondent George Williams. My hesitancy earlier is explained by the fact that our arguments largely mirror that of the plaintiff.
Well, let me ask you a question. First of all, you didn't cross appeal, right?
That is correct, Your Honor.
Yeah, and you're not aggrieved by the order below, right?
Your Honor, I disagree with that, given that we have active cross-claims against the co-defendant in the underlying action.
But to the extent that you wanted to appeal and come here to argue, it's a cross motion, isn't it? Or it's a cross appeal.
Yeah, Your Honor, it went back and forth a little bit on this, but ultimately our notice of cross appeal was withdrawn in favor of supporting the plaintiff's appeal.
If I understand your argument, you support the position of the plaintiff and you have nothing further to argue?
That is correct, Your Honor.
Very good, thank you.
Thank you.
Case 230, Pickard versus Campbell. Proceed, counsel.
May it please the court, Frank Jacobson here on behalf of the appellants, Mr. and Mrs. Campbell. This is a case involving 7 causes of action that the lower court just didn't analyze whatsoever in its decision.
Mr. Jacobson, let me summarize it for my benefit real quick, if I may. The first 2 causes of actions you're saying are precluded by the merger doctrine, therefore the D is documentary evidence under A1, right?
Actually, we'd say all of the causes of action are out by a merger doctrine, but yes, the first 2 are certain.
The first 2, right?
Correct.
And then as to promissory estoppel and unjust enrichment, you're saying, hey, there's an existing contract, and you can't be duplicative of that, so you can't have both. Yeah, you can plead in the alternative, but when you have an existing contract that you've alleged, you can't then have that as a separate cause of action, is your point there, right?
Correct, Your Honor.
And then with the fraud, what your point is, I understood, is that it's essentially just mimicking the breach of contract cause of action. There's no allegation of an independent duty. The only allegation is a misrepresentation that would have been merged into the contract in any event. And the only allegation of the breach is the same as the breach of contract. Therefore, the 4th and 6th go away as well.
Not only is the representation merged into the deed, the misrepresentation is part of the contract, and it comes right from the contract. That being solely that the respondents, and to be clear, the Pickards, were supposed to receive 3/4 of an acre of property. That is the only representation that has been alleged anyway.
They got that, didn't they?
They got that, Your Honor. That is exactly what they got, was 3, and that would be my second point, is you have to have falsity. The problem is that just mathematically, and this is at page 160 of the record, there's a calculation. They got a little bit more than 3/4 of an acre. There is no falsity.
Approximately 0.75.
Correct.
And as part of a certain identified vacant land parcel. Or, no, I got that wrong, about an overall parcel, some of which was vacant. So, but all that's in the contract, as I understand it, is a parcel number, and then approximately 0.75 acres, and your point is, they got that.
Correct.
There's no legal description attached to the contract.
Correct. It was described as 3/4 of an acre located at this particular corner, Jameson Road, and that's exactly what they got, was that. Now, if the respondents were successful in this case, all of a sudden they'd be approaching an acre. That's not plus or minus, that's substantially more than the 3/4 of an acre, which they received. So, as I was saying, this is a case involving 7 causes of action. Lower court's decision, wholly conclusory, just determines they have causes of action, but the merger doctrine, importantly, disposes of all of those causes of action, because not only does it merge the contract, any claim relating to the contract gets merged. Any claim, all claims.
The
That's
contract
all
of
of their
sale
claims.
does not say 0.75 of an acre for the purposes of building a house, does it?
It does not.
It just says 0.75 of an acre. The fact that they can't build a house, and they claim you knew by not including that meets and bounds description with the percolation holes, knew that a home couldn't be built. That's not a fraudulent claim.
Your Honor, that, I want to take back when I said no. The contract does say what they were intending to do with the property. However, there was also, this is vacant land, 100% vacant land. There's a vacant land rider that says you're supposed to do all of your investigation. You're supposed to look at it. You're supposed to do your perk testing. You're supposed to do all of this stuff yourself.
Is that a 30-day
They did nothing.
time limit?
Huh?
Is that 30 days to do that inspection?
I forget the period of time, but it is in the vacant land rider, which is in the contract, and it's clear as day. They were supposed to do their own perk holes. They were supposed to look at the land, make sure it's buildable. That's all clear language within the contract, that it was their duty solely. We had no duty to do that whatsoever. Our duty, sell them 3/4 of an acre of land. That is it. So again, any and all claims that relate to the contract whatsoever are merged into the deed.
We have that argument, Counsel.
That happened. Now, the respondents do argue about ambiguity, repeatedly saying the contract is ambiguous. Problem is that under the merger doctrine, you have to have the deed be ambiguous. They can't point to a single portion of that deed that's ambiguous. Getting to the 2 fraud claims. Again, we say they're relating to the contract, and therefore they also don't survive pursuant to the merger doctrine. But there's no particularity whatsoever of all of the causes of action. Who, when, where, what was said. Who said any of these representations? The only thing that we have is the contract. That's what says 3/4 of an acre. That's the purported representation. Well, it's in the contract. Therefore, it's merged into the deed. Falsity, as I was saying before, it winds up they did receive 3/4 of an acre exactly as they contracted for. That is established by the deed, and it is established by the survey that they were provided. Now, there's also these claims about custom builders. I don't know how the lower court allowed these claims to continue.
Just to get at that, Mr. Jacobson, I don't see any allegation of harm or damages by that plaintiff, do you?
None whatsoever. Essentially, the allegations are that it's a domestic LLC and it's been damaged. That's what their claims are. Even in the respondent's brief, they just say they didn't give back this corrective deed to the Pickards, and therefore we've been damaged somehow. There's no nexus whatsoever between custom builders and the Campbells.
You didn't have a duty in tort or in contract?
None whatsoever, Your Honor. Because, again, there's no privity whatsoever between the parties. As far as injunction, that was, again, something plain as day. New York doesn't even recognize such a cause of action. Lower court should have dismissed that out of hand. Simply stated, the lower court decision should be reversed. Complaint should be dismissed in its entirety. Thank you, Your Honor.
Counsel.
Good morning, Your Honors. Olivia Paulo Lee for the respondent plaintiffs, the Pickards and Custom Builders. First of all, Your Honors, the respondents are an elderly couple, the Pickards, who wanted to simply build their dream home and accept a deed that was reflective of the plot plan, which was submitted and approved by both the Town of Elma and Erie County Supreme Court Judge Panapinto. The deed that was received by my clients, the respondents, was not reflective of the plot plan, but rather excluded.
Was the plot plan attached to the contract?
No, Your Honor. This was, by way of background, the appellants had a plot of land they decided to subdivide.
Just so you know, we do know the facts pretty well, I can assure you of that. But
Of course, Your
in terms of, when you rely on the plot plan, but it's not attached to the contract. The contract even has boxes where you can check to say, we've attached a legal description, we've attached this. Those were all left blank. The only thing that it says is, I think it's approximately 0.75 acres or 0.75 acres.
Your Honor, yeah.
That's all it says, right?
It said approximately 0.75 acres, which was supposed to be the lot that was expressly outlined on the plot plan, which was approved by the Town of Elma and Erie County Supreme Court, Judge Panapinto. That plot plan,
What you just said, is that in the contract?
the approximate 0.75 acres.
No, what you just said about that it was to match what was in the plot plan.
No, Your Honor, it's not expressly outlined. However, the understanding of the parties, Your Honor, was that the subdivision application and what was approved by both the town and the Erie County Supreme Court would be reflected in the ability of the appellants to go out and sell these individual lots. That was not done. The appellants expressly failed to provide the deed and the buildable lot that was required. Your Honor, it was expressly known that the subdivision lots were supposed to be sold by the appellants, and then each individual person who purchased that lot would have a home constructed by the respondent custom builders. Every party who was party to this transaction understood that a single-family home was to be built on the plot of land.
Isn't that the value of a contract, Counselor, in terms of putting what the understandings are in the contract?
Your Honor, yes, Your Honor. However, the description approximately 0.75 acres, it was understood, and in fact, within the contract, it expressly stated that the improvement would be a one-family home. So it was the understanding that a home would be built on the lot. In addition, we don't think that the merger doctrine is applicable to all of the causes of action. The appellants were involved in conducting the perk hole tests. These perk holes were required by the town and Erie County Supreme Court when approving the subdivision application that the appellants submitted. As a result, the appellants knew, they had knowledge superior to that of my clients, the respondents. They knew that these perk holes...
But your cause of action, in your brief, you say specifically you're not relying on a duty to disclose.
What we are saying, Your Honor, in our brief actually is that under our fraud claim, that they had superior knowledge and they did have the duty to disclose.
I'm looking at your sixth cause of action. It's not based on silence or duty to disclose. It's right in your brief.
Your Honor, it was my understanding that we are relying on the duty to disclose. There's two causes of action, Your Honor.
That's true, there are two. I forgot.
I apologize, Your Honor, there were two.
Forgive me, I get that.
So in addition, it's our position that it was a non-negotiable exclusion. The appellants expressly knew that these perk holes were required in order for the lot to be sellable and buildable, not just a buildable lot, but that it was required in order for the lot to be sold, period. Whether it was to the respondents or to another third party, these perk holes were required in order for the lot to be sold. Once the respondents learned that the property that was deeded was missing the holes, the respondents requested a corrective deed immediately. The appellants then attempted to resell at a higher price to the respondents, knowing full well that the respondents needed this additional excluded part in order to build their home.
Your opponent says that the additional parcel required would get the mass being transferred, the parcel, closer to 1 acre as opposed to 0.75. Isn't that a substantial difference, and was that contemplated by the parties?
It was not closer. It was not close to an acre, Your Honor. We're talking about 0.03 of an acre at issue, which is nowhere close. It would have been nowhere close to a full acre. That is not what the parties were intending. We're not saying that a full acre had to be deeded. That's not our position. But our position is...
So you're saying the language approximately 0.75 would reasonably include this additional acre?
Yes, it would, Your Honor. In addition, not only does merger not apply to all of the causes of action, neither the deed, the plot plan, the survey, nor the contract utterly refute our claims. The appellants took intentional acts with knowledge of what the town and the judge's order was from Judge Panapinto. This is a motion to dismiss, Your Honors. Discovery has not even begun, and the respondents have alleged sufficient facts for this matter to proceed. We would request that the lower court's decision be affirmed.
Thank you, counsel.
Thank you.
Case 231, Fox versus McClellan.
May it please the court, Brent Seymour on behalf of defendant appellant James McClellan. As the court is quite aware, this case stems from a pedestrian who was a roadside construction worker involved in a motor vehicle accident. And what we're asking the court to do today is...
Seymour, good morning.
Good morning.
In the respondent's brief, there is a citation to 3 different cases, one of which is from our court. The Diaz is not. Anderson is from our court. And Deering, I think, is also cited. And then cited within one of those cases, Jablonski. All of those cases, including from Anderson, say that where you don't see the emergency, the pedestrian allegedly coming outside the cone, when you don't see it, the emergency doctrine does not apply. And in fact, in Anderson, our court said it was error under those circumstances to give the emergency doctrine instruction. And then in your reply brief, you don't even address those cases cited by the plaintiff. So it looks to me, by not addressing them, one could argue, I suppose, that you must agree that on the law, we cannot apply the emergency doctrine to these facts, correct?
I think it's twofold. I do think there is a distinction that would apply, that would allow the court to apply the emergency doctrine, and that is because we're dealing with this large dump truck, which it is undisputed that plaintiff came from behind the dump truck. Plaintiff own expert.
But doesn't the emergency doctrine require that the emergency be perceived by the person? And that his actions to that perceived emergency might not be held to the same standard. But your client said he never saw the person before the impact. So we're not concerned about what his reaction would or wouldn't have been to an emergency. He never saw the person.
I think it goes to his actions as he's leading up to that dump truck just before the accident, where he is reducing his speed and he is keeping his peripherals open.
There seems to be quite a bit of distinction about reducing his speed. He certainly does testify 10 miles per hour. His wife says 5 miles per hour. But another person who viewed the accident said he thought he was going 35 miles per hour. Isn't that alone a factual dispute as to the appropriate speed in a construction zone?
I don't believe it is a material question of fact. I don't believe there is actual testimony that puts him as high as 35, which in fact was the speed limit. There are people, the coworkers, who put him closer to 20 to 25. One, to the responding officer, says he was not going at a excessive or unreasonably rated speed.
I'm still having trouble, counsel, with the idea, is my colleagues have raised, the idea of the application of the emergency doctrine. How does the speed have anything to do with that if, in fact, the driver never sees the plaintiff in this case?
Well, even if you don't apply the emergency doctrine defense, there still has to be evidence that my client was negligent. So we have to look at his speed, where he was in the roadway, the obstructions that he had, and all of those factors.
And you need to establish that you were not negligent as a matter of law, right?
Correct.
And you base that argument in this case so far on the emergency doctrine, right?
Correct.
Is that what your brief does?
Yes.
Now, if you shift off the emergency doctrine, we're faced with an issue that really is not before us, aren't we, at this time?
It was still, at the end of the day, the motion is made on a lack of negligence by my client. The emergency doctrine was certainly an affirmative defense that we, asserted, and it based much of our argument, but there's still a general argument that is made that my client was not negligent, they were not speeding, and things of that nature.
And Mr. Seymour, how about something that you do talk about, foreseeability? Okay, so your client, or the plaintiff, no, your client, was at a light, up ahead sees a big truck making a big obstruction in the roadway, okay? And yet, when he gets up to the obstruction, we then have to view what his actions are, since he does know there's an obstruction there. There's men working there. There's activity going on. There's the dumping of stone, et cetera, and judge his actions accordingly. Now, if we even consider anything that the plaintiff said, the plaintiff says that he was in an orange vest, that he was extending a flag outward from his body, okay? And outward from, and then it would have to be outward from where the truck, the edge of the truck was too, because he got hit right around there. So doesn't that raise questions of fact?
I don't believe it does, Your Honor, because again, I do think my client was acting reasonably as he approached. The testimony is when he's at the light, which is much further away from the accident scene, that's when the dump truck is completely perpendicular in the roadway and essentially covering the whole roadway. However, as he's approaching 10 miles an hour.
Well, is there any testimony in the record indicating that the dump truck was covering the whole roadway? I thought there was some dispute as to whether or not the dump truck was, at the midpoint or went into the other lane of traffic, but I don't remember anything in the record indicating that it was obstructing the entire roadway, and there seems to be some photographic evidence that it wasn't.
Instructions are on the wall.
That's our tech people, I believe. You can proceed.
Okay. When the truck is covering the whole roadway, that's much earlier on in the time leading up to the accident, when he's back sitting at the red light at the intersection closest to it. Because if you go back a little further, the truck had started in a different position. They were unloading the stone, and then to get basically the last of the stone out of it, they had to move the dump truck into this different position to be perpendicular to the roadway, and then lift the back of it to dump the rest out. So that maneuver is occurring in the minute or so leading up to the accident, and he kind of sees the tail end of that. And then as he's approaching the area of the accident, that's when the dump truck is reversing, and the plaintiff is the one that is waving on and telling the dump truck, all right, you've pulled far enough back, you're good. And now he is then going to go in front of the dump truck to then start flagging for vehicles that were coming from my client's direction, but he never gets to that point. There should have been a flagger up further on the road where my client was coming from, and that's what he was going to do, but he never got there. So there was no indication to my client that there was anyone coming from the other side of this dump truck. And going to some of the points
Counsel,
that...
I keep going back to the speed that your vehicle went through a construction zone. Yes, your client said 5 to 10, his wife 5. I thought Ushold, USCHOLD, estimated that your client's vehicle was traveling 35 miles per hour before it came to a stop, which was at 241 of the record. So certainly there seems to be some discrepancy as to 5, 10, or 35 miles per hour. Now, he didn't see it at the time, but he said when it came to a stop after, so perhaps it was even going faster than his estimation of 35. But clearly, if there's a dispute as to such a large speed differential, isn't that alone a basis to deny summary judgment?
I don't believe so, because in the Fourth Department case law on that issue, when speed comes up in these types of accidents, it's a two-part test. It's, was the speed unreasonable or above the speed limit? And then part two, if the person was going slower, could they have avoided the accident? And again, due to the sudden nature of everything and this large dump truck, precluding my client's view, and it was going to some of the points that Justice Bannister brought up about the vest and the flag. That might have been true for vehicles coming the other way who would have seen the plaintiff the entire time, but my client doesn't have x-ray vision to see through this truck, so what the individual is wearing or what he's holding when his view is obstructed,
Plaintiff
I don't
says,
think it
however,
matters.
he was extending a flag, okay? So if the car hit him and he was extending the flag, wouldn't that flag necessarily be, in the view of your client?
He also testifies that the accident occurs instantaneously as he's making that maneuver. So I don't believe it does, because of, if there was testimony that he had held the flag out for a longer period of time or been in my client's lane for a longer period of time, then that might rise to that level of a question of fact. But when you're talking about such an instantaneous accident where he just comes right out of the front of this giant dump truck and only at that time is the flag out, I don't think it gives my client...
Counsel, I think we have that argument. You can, you should begin to wrap up, though.
Okay. Just two quick things on, there was the...
Mr. Seymour, real quick, just so I can get this question out for my benefit. Just conceptually, when you argue sole proximate cause, it seems to me that's sort of a misnomer, misphraseology. You really need to argue, assuming my client was negligent, then his negligence was not a proximate cause of the accident. That's the burden that you have in any motion like this. The sole proximate cause concept is really something related to the labor law, not here. So, I mean, you haven't asked us to assume argument that your client was negligent, so I don't think we need to get to the causation issue, should we?
I think it's more of a secondary argument to be made, because it brings in the plaintiff's culpable conduct, and I did put in there that under the Rodriguez case law, that even if this court believes that there's a question of fact as to my client's negligence, you could find that the plaintiff was negligent as a matter of law and take that away from the jury, which I do believe the court should find that. So I think it's more of akin to that argument. There was the Augustine case that was also cited by plaintiff that involved the recycling truck, but I think that's very different than my case, because again, my client is within the cones and the barrels that were set up by plaintiff's construction company. In that case, Augustine, the defendant driver in that case basically swerved around a recycling truck and left the proper lane of travel. My client never left the proper lane of travel before this accident. And then lastly, there was an argument about the CV of my expert not being attached to the underlying motion papers. I don't believe that is preserved, that there was no argument made at the lower court about that issue. I understand it's not part of the record, but as an officer of this court, there was a corresponding expert disclosure that had that information that was made at the exact same time as my motion. And if you look at my expert's report, it does list his license number with the accreditation bureau that makes him a certified accident reconstructionist. So that license number is on there. And it also has his website on there as well. So there should be no prejudice there. Any of his credentials are on there and were readily accessible, and I don't think it's preserved.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Matt Kaiser for the respondent, James Fox. And I'll be brief this morning. I think, as this panel has kind of identified, there are just a number of issues of fact here, testimonial inconsistencies that go to the heart of this case. I mean, the first thing is just the configuration of the roadway itself. I mean, the counsel was talking about the lane of travel. There's a question of fact as to what entailed the lane of travel for motorists like the defendant traveling northbound on this road, where you have this chicane with the the truck going over the WO line by several feet, but then defendant kind of oddly testifies that no, the entire lane was open, and his testimony stands alone, but it still raises an issue of fact, and I think from that issue of fact emanate several other issues of fact, including the distance, the berth between the defendant's vehicle and the truck. Defendant testifies it's about 3 to 4 feet, and other witnesses say it's as close as 6 inches. So that may explain why, if the plaintiff was standing where he X'd on that exhibit, which would have been clearly visible to defendant based on the photographic evidence, why he would have maybe been struck by this vehicle if the defendant was under the impression that his lane was open when it actually wasn't. So I don't have much else to add beyond what's in my brief. So unless the court has any questions, we'd ask for affirmance.
Thank you, counsel.
Thank you, Your Honors.
Case 232, Trepovich versus Makowski. Justice Niemoyer is recused. Proceed, counsel.
May it please the court. My name is Steven Stokowski, and I represent Kenneth Turbovich as the executor of the estate of Nicholas Turbovich. There are several legal questions here before the court on this appeal. The big one is related to the cause of action for unjust enrichment, and what is the applicable statute of limitations for the cause of action of unjust enrichment. As a subpart to that question is when does the cause of action accrue in this action in particular? Our key point is the cause of action of unjust enrichment in and of itself is one founded in equity. The Court of Appeals has said numerous times, the Paramount case being the Paramount film v. State of New York, that such a claim is undoubtedly equitable and depends on broad considerations of equity and justice. By definition, the unjust enrichment claim should be considered to be one of equity, and the 6 years statute of limitation should be applicable. We think here that the case that this court should look at is a 2016 case decided by this court. It's the matter of the estate of Shirley Tremblay, where this court determined that a 6-year statute of limitations applied, and it also looked at when did the unjust action occur. In that case, a woman had a certificate of deposits. The estate was asking for the certificate of deposits back. This court said that it wasn't until she was asked for them back that there was a wrongful action, an unjust action, and that would start the accrual for unjust enrichment cause of action. So therefore, we believe that CPLR 2131 is applicable to this, the cause of action of unjust enrichment, which is sort of the default statute that says if it's not specifically included in the CPLR, 6 years applies. All the cases cited by defendant respondent, we believe those are inapplicable here for a multitude of reasons. The first reason being in none of those cases, and this is Ingrammy, DiMatteo, Lambert, and none of those three cases were there any court orders that regarded people giving money, and also a court order, and this specifically I'm talking about the 2014 order that reversed the initial 2014 trial court order by Justice Dillon, saying that people, the estate owed money to Joseph Mikowski. Also, some important things to point out here as well, too. One of the cases cited by defendant respondent, Elliott v. Quest, 25 AD 3D 1897. In that case, plaintiff thought they were buying stock, so they sent money in 1995 to a broker. They never got the certificate of stock, so in 2002, they realized this, they asked for the money back. So 7 years after the fact, they're realizing, hey, I was supposed to buy the stock, I never got it. In that case, while the court said the wrongful act happened in 1995 when the stock was never purchased, the court applied a 6-year statute of limitations period. And if by defendant's argument, that would be monetary only. He was asking for the money back in that 1995 case. We believe here this remedy is more like a disgorgement of lost profits. And while there is the case, the New York City Econ Development Corporation.
When did you first make the disgorgement of profits part of your argument?
That was I believe that was before the trial court. That was on the.
You made that argument before the trial court. In terms of the appeal, did you make that argument in terms of the appeal, or was it raised in your reply brief?
I believe it was raised in the initial brief.
Okay, we'll take a look at that.
I believe it was. I have that case cited, so. But we believe it's more akin to the disgorgement of profits. There is a case that says disgorgement of profits, more relates to, it talks about the SEC and things like that. However, it also talks about a quasi-government agency, which is or quasi-government agency or government entity, which in this case is the court. And so we're looking back at these 2014 orders, which come from the court, which is an agent or an arm of the government. Also, in regard to some other cases cited by defendant respondent, access.
One last thing, counsel, with respect to the disgorgement of profits. Was that raised at all in any of your pleadings in terms of the complaint of the bill of particulars?
I believe that was, wasn't, so initially there was a summary judgment in lieu of a complaint that was turned into a complaint. And then after that, there was the motion to amend. There was no discovery done.
No, I'm just asking if it was alleged.
If it was alleged, no. I do believe in the amended complaint, we talk more directly about how this unjust enrichment, which was not allowed to proceed. We talk more so how this would be an equitable remedy. And just briefly, in regard to the motion to amend, as this court is well aware, those are usually freely given. There's been no written discovery done. And so I think defendant's primary argument stems from, if there's a statute of limitations in place, then we shouldn't be allowed to amend. I think if that court decides in the affirmative on that, then that's taken care of.
And the reverse is true. I mean, if we determine it's only monetary relief being sought, then it's a 3-year statute of limitations, then there'd be no reason to amend.
Yes, then in theory. Unless, the only argument to that would be is when does the statute of limitations accrue here? The first formal demand in the record did not happen until early 2019.
When did the court issue its decision in this case?
The lower court was...
No, I'm talking about our court.
Yeah, 2014 was, November 2014 was the order saying that the lower court, trial court's order of attorney's fees was overturned. And then in regard to allowing, this is just a brief point, the motion for renewal and re-argument, the defendant argues primarily that there was a new fact or new legal theory. The cases relied on by defendant, 2 of them in particular, Olean Urban Renewal Agency, and the matter of field home Holy Comforter. In both those cases, there's no mention that the cause of actions were the new cause of actions were discussed at an oral argument. In both those instances, it appears that after oral argument was conducted, the motion for renewal and re-argument was made in regard to new causes of action that were being asserted. In one case in particular, the court itself asserts a cause of action into the matter. So we think our situation is different than those. And I think to prove that point, the cause of action of conversion, for example.
Would you agree that when the court inserted that cause of action at the end of the argument, that was really the first time the other side would have had an opportunity to address it?
I respectfully disagree with that. I think that the initial papers, while not saying unjust enrichment explicitly, our initial papers undoubtedly include the elements of what an unjust enrichment cause of action.
Didn't your papers specifically say that you weren't looking for unjust enrichment?
The initial papers talk about just monetary relief.
Right.
But what's interesting is if you look at the conversion unjust enrichment cause of action, defendant did in its papers talk about how that would be time barred in the initial motion to dismiss. So by way of that, if they have a reasonable excuse for not bringing up unjust enrichment, they clearly thought of conversion and brought up the reason why they believe that should be dismissed under the applicable statute of limitations. And that was also discussed and brought up, I believe, in oral argument on the first motion.
I think we have your argument, counsel.
Good morning. May it please the court. April Orlowski on behalf of Joe Makowski, the respondent in this matter. I think what the appellant's counsel is overlooking is this is not a case that was brought by a summons and complaint where there was 6 or 7 causes of action, one of which being unjust enrichment. This was a case that was commenced by summary judgment in lieu of complaint pursuant to 3212, in which the only cause of action is available is an action for the payment of money only. Throughout the lower court's proceedings in this case, the plaintiff specifically reiterated that they were seeking a money judgment, not a judgment based upon equity or equitable principles, a money judgment. So the defendant responded, proceeding to oppose a 3213 motion. Didn't address the equitable cause of action for a money judgment. And I think one of the points that defendant made about how, and Justice Whalen addressed this too, about disgorgement. The disgorgement issue, so disgorgement of profits, disgorgement of fees, that wasn't brought up until the motion to renew and re-argue. But that doesn't matter anyway, because there's a case out of the First Department titled Access Medical that regardless if you call it disgorgement of fees or profits or anything like that, it's just semantics. You can't use semantics
to change a cause of action that's for money, therefore subject to a 3-year statute of limitations, into one that's equity and therefore subject to a 6-year statute of limitations. In fact, the court in Access Medical was faced with a situation which is eerily similar to the one faced in this case, in which the plaintiff was seeking the return of attorney's fees. So I think that case alone specifically sort of says where where the appellant's case fails. And also, this court has addressed the issue of the 3 versus 6-year statute of limitations in its decision in DiMatteo, where the plaintiff sues to recover proceeds from real estate sale. That case, the court said that it was subject to a 3-year statute of limitations because it was a money sale only. The plaintiff was seeking money only. I want to address the court or the plaintiff's argument that this is accrues on even if it's subject to 3-year statute of limitations, it is timely because it accrues in January or July of 2019. Respectfully, Your Honors, that's kind of a specious argument. If we go with that argument, it sort of makes statute of limitations unnecessary or with no purpose whatsoever, because you could wait 40 years, make a demand, and revive a dead statute of limitations by simply making a demand. Here, the court issued the order upon which the plaintiff based his 3213 motion on November 21st, 2014. The statute on this case began to run on November 21st, 2014. Therefore, it is untimely when the plaintiff brings his action in 2019. I also want to briefly touch on the fact that we didn't do anything in this case addressing the issue in the underlying action, so therefore we can't bring it up. I think the court, and I'm paraphrasing here, the court below said it best, and this stems from questioning during oral argument. Counsel for the plaintiff at that time was responding to questions from the judge about whether or not the order was applicable because it had been reversed. Now, I don't know if the judge was correct on that issue, but that's neither here nor there. But in response to those questions, counsel for the appellant said, well, it's unjust enrichment, Your Honor. And the judge turned to defendant's counsel at that time and asked, well, is it unjust enrichment? And again, I'm paraphrasing, or why isn't this unjust enrichment? And immediately, and instead of ultimately like jumping right into an answer, counsel said, this isn't unjust enrichment, it hasn't been pled. We haven't had a chance to address that. So the court, in its then opinion on the motion to renew and re-argue, said that, and again I'm paraphrasing here, but when the court converted the complaint and then the answer into the 3213 motion into a complaint and answer, it didn't allow the defendant
Yeah, the
to
court
address.
ultimately said this is a cause of action on unjust enrichment, but you weren't addressing that at the motion, right?
Not at all, Your Honor.
In fact, that had not even been pled.
That's absolutely correct.
Right, and so that's the reason why you hadn't had an opportunity at that point to address those issues, right?
Absolutely, Your Honor.
I think we understand.
Thank you very much.
Thank you, Counsel. Right, okay. Case 233, Fractional Strategies, Inc. versus Geneco. Counsel, proceed.
Good morning, Your Honors. John Tantillo for Appellants David Geneco and Smeco LLC.
We're asking for summary judgment today on 3 points in this appeal. First, that plaintiff has failed to introduce any sufficiently specific evidence or even allegations of unpaid fees for the work that he actually did do. Two, that plaintiff is not a licensed real estate broker, so he cannot receive commissions for the sale of real property, which, as an aside, it is undisputed is work that he did not do. And three, that Mr. Ginecco himself is not personally liable under the contract. If I can just address that last one first, because I think it's the quickest. We're not, as plaintiff and the court below appeared to believe, arguing that Mr. Ginecco, or that we should receive a judgment that Mr. Ginecco cannot be held liable via the theory of piercing the corporate veil. We recognize that that's a factual issue that could be addressed later. What we're seeking now is just a judgment that Mr. Ginecco is not personally liable based on him being a party to the contract. We cited a Court of Appeals case that specifically held that where a party signs as president of a corporation, it is a corporate signature and not a personal signature, and that's exactly how Mr. Ginecco signed here. Further, the signatory to the contract is defined specifically as a domestic corporation, not a person and a domestic corporation. On the commissions question, I think it was where the trial court got slightly mixed up. We are not arguing that the contract is entirely void because plaintiff is not a licensed real estate broker. We fully recognize that plaintiff did work for the project, which did not require a license. We're simply saying that he was paid for that work. The commissions point is raised specifically because plaintiff cannot receive commissions for sale of real property for procuring purchasers, which is work that he did not do. Now, plaintiff and the trial court both point to cases where similarly unlicensed parties were determined to be entitled to payments under contracts which contemplated brokerage services. These cases aren't really responsive to the question in this case, however, because we don't contest that they're entitled to payment for their non-brokerage services. They are entitled to payment. They did receive that payment. Further, unlike those cases, this is not a situation where a party is trying to misuse the RPL 440A to kind of avoid payment for services rendered because, one, plaintiff drafted this contract, not defendants, and two, these services weren't rendered. He didn't procure purchasers. The contract has a specific clause that says there's a test for determining when Mr. Elsmore or Fractional Strategies was to be entitled to receive commissions, and it's upon procuring a purchaser XYZ conditions about signing the contract.
So if I understand your argument, you're saying that to the extent that payments were made, those payments were made for, say, the marketing and the non-procurement of buyers and the closing on deals. It was for those other things they were paid for. But any additional commissions fees would be inappropriate because they weren't a licensed real estate agent.
Correct, and because he didn't procure purchasers.
Well, I mean, first of all, your argument is, even if he did procure purchasers, they're not entitled to commissions on those because they're not a licensed real estate agent.
Right, we argue that they're entitled to their hourly fee, which they received. I think in their response brief, they even admit that at pages 24 and 25 that they received that fee. The services were for things like consulting. Mr. Elsmore was an expert in fractional condominium projects, and Mr. Ginecco wasn't, so he needed help understanding how to get these projects through, and Mr. Elsmore helped him with that, and I think he worked on some plans, and all manner of other work over a course of multiple years that he was paid for. The contract specifically provides that in order to receive payment, Mr. Elsmore was to submit an invoice. And despite that fact, not a single unpaid invoice has been produced in this case. Mr. Elsmore received his fees for the work he did do. He cannot get a judgment saying that he should receive commissions for work that he didn't even do. And Mr. Ginecco did not sign the contract as himself. Thank you, Your Honors.
Thank you, Counsel.
May it please the court, Christine Celeste for Plaintiff Respondent Fractional Strategies, Inc. I'd like to begin just by noting that the contract, the consulting agreement at issue is not illegal, and plaintiff is entitled to compensation thereunder because it required various non-brokerage consulting services that did not fall within.
Your opponent says you were paid for those.
So I was intending to get to that point. what defendants fail to comprehend is that the consulting agreement at issue always provided that compensation was to be made by commissions less any advance payments. It was not hourly fees for the prior non-brokerage services and then commissions only for future services that were allegedly brokerage services. It was always going to be commissions less advance payments. While defendants did pay certain hourly fees, plaintiff is in no way conceding that it was paid in full, and it was always entitled to commissions on the back end. That would go to the next point that that defendant's counsel raised, where first he's alleging that we are not entitled to those commissions because it would be illegal under real property law. But the consulting agreement at record page 68 lists the various duties that plaintiff was to perform, including
marketing, administration, budgeting, things of that sort that had nothing to do with the commission.
Correct. And in fact, in the 4 years that the plaintiff did perform work at the project, it performed various non-brokerage services, including preparing and obtaining approval of a 350-page plus offering plan, developing facility and unit layouts, developing a project website, renderings, marketing materials, and actually working with a licensed real estate sales agent that defendants hired themselves. This was Julie Fisher. It also bears noting that the addendum A to the agreement at record page 68 provides that the plaintiff was to recruit and manage various real estate sales agents, and that at the top of that, at the top of page 68 of the record, that certain brokerage duties that may have been performed would be performed by project paid consultants that plaintiff will manage. It was never contemplated that plaintiff was going to be performing these services itself. And to go to defendant's argument that even if we got to the point of the condominium sales that we are not entitled to commissions because we were not the procuring cause of sale, I would argue that all of the background work, the 4 years and what was supposed to be more than 4 years that plaintiff performed leading up to the sale of the condominium units, that all qualifies as being the procuring cause of sale, even if he didn't and wasn't supposed to be the listing agent. He still was the procuring cause. I do want to note that, excuse me, that defendants also try to avoid liability by claiming that plaintiff did not object to its purported termination in 2014. Although Mr. Daneco's partner tried to unilaterally terminate the consulting agreement in 2014, the agreement itself expressly states at record page 66, this agreement will not be terminated if developer sells substantially all of its assets or corporate shares, or terminates its business, or merges, or is consolidated with any other business. The agreement also has no termination clause. This raises the points of defendant's claim that plaintiff waived its right to enforce the contract or its right to compensation thereunder. But this fails because plaintiff never manifested an intent to waive its right to compensation thereunder, and it did not unreasonably delay in bringing suit once it discovered the defendant's breach in 2019.
Thank you, counsel. You should begin to wrap up.
All right. As a final note, I would just like to state that while plaintiff contends that the denial of summary judgment should be affirmed on the merits, it also should be affirmed based on prematurity due to the lack of discovery. There were outstanding discovery demands to defendant. He was noticed to be deposed, and plaintiff had not had the opportunity to discover these facts.
Very good. Thank you, counsel.
Thank you.
Case 234, Reno versus Wheatland Chili Central School District. Proceed, counsel.
Good morning, Your Honors. Julian Baumrin from the law firm of Harris Beach on behalf of the defendant appellant Wheatland Central School District. May it please the court, we respectfully request that the decision below be overturned. It was based on an overbroad
So
interpretation.
counsel, your position, just so I'm clear that I understand it, even though a person is a mandatory reporter, they're only required to report child abuse by a person legally responsible for that child. In Yolanda D., you say the Court of Appeals said that cannot be a teacher.
Yes, Your Honor, that's exactly our position.
Okay, so point one is because it's a teacher, there's no mandatory reporting requirement.
For purposes of a social services law 420 claim, yes, that's absolutely correct. Thankfully, there is a statute that was written in 2000, Education Law 23B, that does apply to teachers and administrators and persons at educational institutions being responsible to report other teachers and administrators. So that has been written since the 1996 decision that this court put forth in Kimberly SM. So any concern that taking a bite out of a social services law 420 claim by saying it doesn't apply to a teacher as somebody, a person legally responsible, doesn't leave children from a policy perspective without the protection of this new statute from, well, I say new, but new-ish from 2000 that does apply to teachers in that context. So, and
Counsel, your second argument is that the pleading, the proposed pleading is insufficient and palpably improper. Why is it?
because it doesn't plead facts necessary to permit the court to conclude that any failure to report was knowing and willful.
And you say it needs to be both? Knowing and willful?
Yes.
And there's no allegation that, in this case, they knew at the time?
No, not based on the pleadings. There's no allegation. I believe the language was should have known.
Knew or should have known.
Right. So it's basically the standard negligence pleadings. So I wasn't ready for a question that early, Your Honor, but thank you because you kept me on my toes.
My pleasure.
I thought that was kind of a late question.
I drove all the way here from Manhattan, so maybe I'm just a little slow today.
morning?
Last night, very late, yeah. So I'm going to get back to my hook that I had written for myself. This is a rare situation where I'm seeking to have a decision overturned that has already been deemed invalid. Not by this court, obviously, because that's what we're doing here today, but the Eastern District of New York has already said that this specific decision, not the basis or the rationale behind it, the specific decision on the re-argument motion below was decided improperly. So the Eastern District of New York says that in re Yolanda D is the operative precedent when a teacher is involved in an allegation of sexual abuse under Social Services Law 420, that the way that the in re Yolanda D court, the Court of Appeals, went through the analysis is the proper analysis. That a person legally responsible is determined by the legislative intent behind the statute, which was to get children out of abusive homes. That was the reason they wrote it. And the Court of Appeals said that because of that, a person legally responsible has to be somebody who serves the functional equivalent of a parent. And it specifically said that a teacher or somebody with fleeting responsibilities as an educational institution does not count. The court below actually appreciated that and understood that, and that was their first decision. Then upon re-argument, when presented with the Kimberly SM case from the Fourth Department, changed course. Now I should note that In re Yolanda D was decided 17 days before Kimberly SM. There's no indication that the Fourth Department, in deciding Kimberly SM, knew that this issue was even pending before the Court of Appeals. In re Yolanda D was a family court proceeding to remove a child from custody of family members. So it wasn't necessarily a social services law 420 claim that would have put this court's attention to look at the docket and say, oh, let's wait for this decision to come out and see what the Court of Appeals says, for example. So in re Yolanda D was correctly decided. The reasons are something from the Bill Murray movie Scrooged. The past, the present, and the future. The past, the legislative history, is clear that a teacher should not qualify as as a person legally responsible. The legislative history says that clearly. In re Yolanda D, the Court of Appeals specifically says teacher doesn't count. Kimberly SM was decided, honestly, properly under the facts in that case. It was a situation of bad facts potentially making an overbroad decision. In Kimberly SM, there was a child who told a teacher that her uncle was doing something to her in the home. Told the school. And the school said nothing. That's obviously not something that anybody wants to happen. So under those facts, the Fourth Department said there's a question of fact regarding the status of this uncle because this child was spending considerable amounts of time at the person's home. So there was a question of fact precluding summary judgment on the issue of whether this uncle was a person legally responsible and the claim should move forward. The Court of Appeals in re Yolanda D does not take a necessarily conflicting point of view. It just says teachers don't count. Now,
Well, they went and said teachers who provide extended daily care of children in the institutional setting.
Of course.
That's not to say that a teacher in other ways couldn't.
Of course, Your Honor. That's actually what I was going to get to eventually. Because there is...
Move you along.
Right, thank you. There's nothing precluding a complaint from saying this person is a teacher, and the plaintiff also spent 2 weeks a month at this teacher's house because their parents were in Europe for 6 months. That's a different situation where there may be enough to get past the motion to dismiss because there could be facts in the complaint that could potentially lead to the conclusion that this person was serving the functional equivalent of a parent. But in this case, the pleadings say Mr. Raftery was a teacher and a coach. That's it. Nothing. And if anybody would know what role this man played in the plaintiff's life, it's the plaintiff. She could have put it in the pleadings. So it's not in there, which means they should be held to the four corners of the pleadings.
Counsel, you should begin to wrap up.
Okay, thank you. The present, in 2015, the Court of Appeals reaffirmed its holding in re Yolanda D, said it still has continuing vitality, and in re Trinacia J. Like I said, this year in September, after we wrote this appellate brief, the Eastern District of New York came down in PC 41. I put that in our reply papers. The policy, when I say the future, the policy concerns are if we allow a motion to dismiss to be denied on a social services law 420 claim, when the pleadings specifically say a teacher only, then we're permitting all of these Child Victims Act cases to go forward on these claims where the defendant may actually not be allowed to be liable in the long run. Under the statute, there is no way that a teacher can be...
We have that argument, counsel.
Okay. Thank you.
Thank you.
That's what I have.
Good morning, Your Honors. May it please the Court, Stephen Boyd for Kathleen Reno. Your Honor, the Yolanda case, which was cited by the Fourth Department in the Kimberly case, the Fourth Department clearly knew about it because they put it in the decision, is not a mandatory reporting case. It's not a school case. It's not a case that involved a teacher. It doesn't have to do anything with mandatory reporting. And the reference to a teacher as a person legally responsible is pure dicta. It has nothing to do with the holding in that case. And the Fourth Department 17 days later must have realized that when they decided the Kimberly case. The appellant is asking you to make a very narrow finding of what is an abused child, requiring only certain legally responsible people can abuse children. And that's not what the mandatory reporting statute says. The mandatory reporting statute is akin to a fire alarm. If a person sees a fire, do they pull the fire alarm, or do they say, I wonder if it's a fireplace fire? I wonder if it's a gas fire? It might be an electrical fire. I don't know. And they walk away? No. And reporting child sexual abuse, reporting maltreatment of children is far more important than a building being burned down. Once the mandatory reporter has reason to know that a child is being maltreated or abused, or God forbid, sexually abused, as Katie Reno was, they have to report. And that's what this court said in Kimberly. Now, if this court today were inclined to follow the dicta in Yolanda, where there is a little side reference to a person legally responsible can't be a teacher, I would point out to you that they make no reference to coach. And the perpetrator in this case was a teacher and a coach. So a coach could be legally responsible. I would submit you should not follow the logic of the dicta in Yolanda. You should follow this court's precedent in the Kimberly SM case.
You say that duty to report would be greater than, and let the investigatory agency that you report to make a determination as to whether the person is legally responsible for the child.
Yes, that's step two. That comes later. And why is that, Judge? Thank you for that question, because the reason the person has to report is because it stops the abuse. It stops it right then. We don't wait to find out or to do some analysis of, I wonder who this person might be. I wonder if they're technically legally responsible adult in this child's life. We don't need that analysis. We need the abuse to stop if we're going to protect children. And that's what the mandatory reporting statute was designed to do. It wasn't designed to do some prosecutorial analysis of whether a case is founded against the abuser later. The mandatory reporting statute is put the fire out now. Stop abusing this child now. We'll figure out the rest later. And I would point out to the court, speaking of figuring it out later, we're at the complaint stage. Every case this morning has been arguing the facts of the case, the evidence, the deposition, the documentary evidence. We're at the complaint stage. If we can't prove our case, later in the case, they can move for summary judgment. They have another remedy. But to take away our ability to bring this cause of action in a complaint is a complete miscarriage of justice. We would submit that Judge Chimes got it right the second time. She got it right when she decided the earlier case and allowed this cause of action to go forward. And we ask this court to affirm.
Thank you, Counsel. Case 235, Massey versus Whitlinger. Proceed, Counsel.
Good morning, Your Honors. May it please the court, Laura Gardner for the defendant appellant, James Whitlinger. As the court is well aware, this involves two issues. We have a serious injury threshold and a negligence motion that were both granted in favor of the plaintiff. We appeal from both aspects of that order. With respect to negligence, I would refer to this court's decision in Joannis versus Cahill, which presents essentially identical facts as far as the happening of the accident. And I would rest on our brief unless Your Honors have any questions as to negligence.
No questions, Counsel?
And if I may just make a few points on the serious injury aspect as well. As an initial matter, the lower court found that plaintiff met his burden on the injury question. We submit they did not, particularly because they chose to attach the affirmation of Dr. Huntoon as part of their initial motion papers, which, as described throughout our papers, represent several issues of fact that would preclude summary judgment in favor of the plaintiff on this question. And so because the plaintiff's initial submission had issues of fact, they never met their burden. The burden never shifted to the defendant to raise an issue of fact, and their motion should have been denied. The court did correctly look at both whether the defendant met their burden, because we were moving at that time as well, and whether the plaintiff met their burden. The court found plaintiff did, defendant did not, and then it seems as though the analysis stopped there. There was no question as to whether there were issues of fact that prevented summary judgment in favor of the plaintiff despite meeting his burden. Here we have...
We need to compare Dr. Huntoon with Dr. Zeidman, I think is the name.
That is correct,
That's
Your
really
Honor.
what we need to do on this case, if I understand your point correctly.
That is correct, and those two opinions are contrasting in almost every way, whether there's degenerative findings on the post-accident film studies versus traumatic, whether the EMG studies support a finding of radiculopathy, whether the plaintiff was physically capable of returning to work. Those two positions.
This is a 19-year-old plaintiff, correct?
He's 19 at the time of the accident.
When
that's
does
correct.
degeneration of the spine start, do you think?
Dr. Huntoon cited some studies in his report that actually indicate between the ages of 10 and 19 in males is when they start showing signs of degeneration. He also noted the findings of osteophytes that take years to develop, and in his opinion, it's medically impossible.
Degeneration starts almost as of the time of born.
That is correct, according to the study submitted by Dr. Huntoon. Females, I believe, is significantly later, but he explained this, and he explained that it's essentially a medical impossibility that these osteophytes could have been developed between the accident and when the film study was taken. So really what we have, and what I believe you're highlighting,
But
Your
Dr.
Honor,
Huntoon doesn't dispute that there was nothing in any prior treatment records of this person's back injury before this incident.
that is correct. There's no documented prior treatment to the neck or back for this plaintiff. And
Not only medical, but all indications are that this plaintiff was playing sports just prior to all of this and was very active, right?
that's the plaintiff's testimony. That is correct.
Yeah.
And I think all of that, as the lower court highlighted, would come into play whether defendant met their burden on summary judgment based on what plaintiff has argued as conclusory statements in Huntoon's report. However, we're looking at whether the plaintiff met his burden and whether those aspects of Dr. Huntoon's report raise an issue of fact. And I would submit they do raise an issue of fact. And to find that because there were no prior complaints, or because this was a young plaintiff, there's no, that Dr. Huntoon's report is conclusory as a matter of law would be to make a credibility determination that's not appropriate in the motion stage. It's a decision, a very classic battle of the expert that should be decided by a jury in this
We'll
case.
take a look at that.
Thank you.
Thank you, counsel. Case 236, Eisenhower versus Watertown City School District.
Good morning,
Proceed,
Judge.
counsel.
My name is William Ryan from Tabner, Ryan, and Kennery in Albany, New York, and we represent the petitioner's appellants in this case. May I proceed with my argument, sir?
Please proceed, counsel.
One of the primary issues in this case, judges, is whether the enabling legislation adopted on May 1, 1901 in Chapter 620 of the Laws of the State of New York, or Section 259 of the Education Law applies. And in connection with that issue, there are certain salient facts that have been admitted in the record that I want to list for you right now before I proceed to the statutory authority for our recommendation that the lower court decision be reversed. First of all, the Flower Library is a municipal library created by special act of the legislature in Chapter 620 on May 1, 1901. The mayor, by and with the consent of the Common Council, shall appoint 11 trustees of the library whose term of office shall be fixed by the mayor. 3, the Common Council must raise at least $5,000 annually by taxation in like manner as other taxes are raised in the city, and place the same at the disposal of the trustees of the library for the care and maintenance. There is no mention within the charter for funding through taxation by other municipalities or districts. 4, the district shall care for and maintain the said library and property as a free public library for the city of Watertown. 5, the Watertown City School District is a municipal corporation and extends beyond the geographic boundaries of the city of Watertown. The petitioners are residents of the town of Luray. A portion of the town of Luray is located within the jurisdictional boundaries of the Watertown City School District. As residents of the town of Luray, the petitioners cannot vote in any mayoral elections nor for the election of any common council members. On May 26, 2020, the Watertown City School District and its Board of Education approved the ballot proposition for the school district election in June of 2020. Proposition number 1 stated in part that pursuant to Education Law Section 259, shall the sum of $75,000 be raised by annual levy of a tax upon the taxable real property within the Watertown City School District. The final fact that is unrefuted is that the proposition was approved by the voters of the school district. In your analysis, we are recommending that you take those facts that are unrefuted and apply them to section, initially, 255 of the Education Law of the State of New York. Section 255, Your Honor, states that by a majority vote at any election or at a meeting of the electors duly held, any county, city, village, town, school district, or other authorized body authorized to levy taxes. This section is also known figuratively as the authorizing section for the establishment of a library. You have to take that section and compare it with section 259. But before you do that, you have to look at, there's an opinion from the Office of the State Controller that was issued in 1983 that is very probative of the issue before this court. And that controller's opinion states in part that there is no statutory authority for a library board of a municipal public library to determine to submit its proposed budget to the voters. We believe special legislation would be required to authorize such a procedure.
So counsel, they didn't submit a budget. They submitted a proposition to raise a certain amount of money to support the library to the voters within the district.
Correct. But Judge, they asked within that proposition to have $75,000 funded for its operation.
They certainly did, yes.
And if you, the next point that needs to be raised in response to your question, Judge, is the fact that this is not a school district library. That's front and center of any analysis that needs to be undertaken here. This is a municipal library that was chartered in 1901.
So a municipal library cannot take funds from a school district if they offer it as part of their budget?
That is correct, sir, when the school district has not formed its own library district. And in this particular case, Judge, there's been no proposition placed before the voters in this, within the geographic area of the Watertown City School District for the formation of a school district library. The only library that's in effect here, or operational per the statute, is the municipal library that was established in 1901.
And the school district can't make a decision to help support that public library that's available for the residents of the school district?
The school district ultimately can if they petition the voters of the school district to form a school district library. And the question that you and Judge Bannister posed can be reviewed, frankly, in Section 259 of the Education Law, and also from the Appellate Division's decision in the George F. Johnson case. Now, in section 259,
which provides that taxes may be voted for library purposes by any authority named in section 205. You're saying the school district is not one of those entities?
the school district is not one of those entities because the enabling legislation in 1901 established the Flower Library as the municipal library. And it's been that way from 1901 until now, well, 2020. That's exactly correct. And if you look at 259, Judge, the only...
Counsel, I'm going to end your argument if you did not keep your mask
Oh, I'm
above
sorry.
your nose, and I'm not going to mention it again.
Sorry, I apologize.
Proceed.
Thank you. Section 259 references, in the case of a school district, the appropriation for library purposes shall be submitted to the voters of the district as proposed by the Library Board of Trustees. Here,
Isn't that exactly what happened?
no, that's not what happened here, Judge. The record speaks to the fact that the municipal library director, who's an employee of the city, the library director requested, and other individuals from the city requested that the school district put this matter up for a vote, and that's what happened here. It was under the law, a municipality has no right to referendum a vote unless it's set forth in section 259B12 of the education law. The other salient point here with regard to section 259 is that the underlying enabling action says that the funding and care and maintenance rest solely on the Common Council. Taxes in like manner can only be levied as other taxes within the city. The enabling legislation also states that you cannot solicit or accept taxes, no funding through taxation from other sources, which is what happened here. The school district was not the authority which established the library in the first place. It was the enabling legislation, and the authority which established the public library to later increase the taxes by a vote is not intended to allow any authority to establish taxes for a library which the authority did not create. And
Also, be mindful of your time.
And that is set forth in the George F. Johnson case. The important thing here, judges, is that it's not a school district library. It's not established by a vote of the school district. The Board of Trustees are appointed by the city, not elected by the school district residents. And we're deprived of our ability to do all of that because we are not citizens of or residents of the city of Watertown. Just in closing, Judge, there's a couple more points that I want to raise.
Very briefly.
Okay, Section 310 of the education law does not apply here, Your Honor, because the statute references actions by trustees of the school library and actions by any district meeting in relation to a school library. The library involved in this dispute is not a school library, but rather a library authorized by a special act of the legislature. The proposition in question had no effect on the school district budget, election of school board members, school district funding, or other school district functions properly placed on the ballot. It's a non-school library over which the Commissioner of Education had no jurisdiction. There is a remedy here, as opposed, well, the remedy is one of three things. Number one, this court can rescind or order the charter to be rescinded that created the library in 1901. The school district can create a school district library. Or three, there can be a joint library formed between the city and the school district.
Your time's up, Counsel.
Thank you. And I apologize about the mask and the heat about it.
Good afternoon, Your Honors, and may it please the Court. I'm Ellen Bach, representing the Flower Library on this appeal. And I want to go to the exhaustion argument that Mr. Ryan raised last first, because the matter shouldn't even be here. The Court doesn't have jurisdiction. He references Section 310 of the Education Law, but also Education Law 2037 applies, and it is mandatory that disputes regarding school district elections go to the Commissioner of Education. This is entirely about a school district election and a school district tax, and the Commissioner has full authority and, in fact, must hear this in the initial case. And for exactly the sorts of reasons that are presented here, that process is uniform, it's fast, they were supposed to go to the Commissioner within 30 days, and it's caused, there are results for not following that specified process. We would also submit that the matter, that the full set of claims, including the constitutional claims, should have been dismissed for lack of jurisdiction, because this court and the Court of Appeals have both been very clear that a petitioner can't do a workaround the Commissioner by bringing constitutional claims along with his or her claims with respect to the education law. So it should all have gone to the Commissioner. That's particularly true here. The facts that Mr. Ryan lists as undisputed, many of those are disputed facts. There are multiple issues with regard to the election, who actually initiated the proposition, whether the procedure was correct, whether there was a scheme or some sort of corruption in the process. Those are disputes. They should have gone to the Commissioner for the development of a record. Turning to the merits, I think that it would be helpful to put the claims in context in terms of how libraries are funded throughout New York State. We have a lot of different kinds of libraries in the state that provide free public library services. We've got village, town, city, county, school district, special district, association. That's not even a complete list. And the legislature has never intended, has never said in any way that it requires, as Mr. Ryan would have the court understand, that only the entity that creates the library may fund the library. We share libraries in New York State. We have sort of a hodgepodge of types of libraries, and the legislature has never meant for each and every little village to have its own library so that it can help fund the library. They've created mechanisms by which communities can share not just the libraries, but the cost of supporting the libraries. And critically here, they've created mechanisms by which the voters can vote directly to support their local libraries. So we've got more than 55 municipal libraries in the state of New York that are funded by school district voters. And we've got another more than 200 libraries of other sorts that are not school district libraries that are also supported by school district voters. And then, of course, school district voters do also support school district public libraries. Your Honors, the idea that Chapter 620 of the Laws of 1901 somehow is a bar to the exercise of Education Law 259-1A is just belied by a plain reading of that legislation. That legislation requires two things of the city: that it pay $5,000 in taxes to support the library, and that it appoint the trustees. It makes the care and maintenance of the library the obligation of the trustees, and it doesn't limit their ability to obtain tax funds from other sources, as authorized in Education Law 259-1A. If Your Honors have no further questions, actually, before I sit down, I do want to just mention the constitutional claims, because there are those hanging out there. Somehow this is purported to be a violation of due process, taxation without representation. But of course, the critical fact here is the legislature, which holds, the state legislature has the power of taxation. It gets that power from the people. It has here very purposefully, very consciously given it back directly to the voters. They represent themselves directly. And There's no argument here that the Eisenhowers have had to pay more than their fair share of the school district tax. They're treated exactly like every other taxpayer in the school district.
I think we have that argument, Counsel.
Thank you very much, Your Honors.
May it please the court, I'm Charles Spagnoli of the law firm of Frank Miller for Respondent Watertown City School District. Ms. Bach has very capably presented most of the points that I was going to cover, so I will be very brief. As Justice Bannister observed, the education law, section 259 contemplates a certain process, and that is exactly the process that was followed by the school district without any discretion on the part of the school district whatsoever. Fully agree with Ms. Bach's point about administrative exhaustion. These issues should not be before the court because this is an issue squarely governed by education law, section 2037, and within the commissioner's exclusive original jurisdiction. With regard to the coverage of education law, section 259, in terms of a municipality such as the city or the library submitting a proposition to the school district for funding of a non-school district library, that issue was resolved by the Commissioner of Education's decision in appeal of Earlville Public Library or Free Library. He's the officer charged with interpretation and application of that statute, and it is his interpretation of that statute that enjoys deference. I would also point out, Your Honors, that if we were to adopt Mr. Ryan's argument regarding how section 259 must be applied, that is only to allow such requests to be made to the creating or by the creating authority, then this library would be limited to receiving $5,000 a year from the City of Watertown, because the City of Watertown is not the municipality or the entity that created the library. That library was created by a special act of the New York State Legislature. That is an absurd result, and we do not believe this court should comment. If there are any questions, I'll take them. Otherwise, thank you very much.
No questions. Thank you.
Thank you, Your Honor.